What steps should you take if your child is hurt in Charlotte, North Carolina? Let's start with what exactly is a child injury claim? It's not the same as when adults get injured. Kids don't see things the same way, and their understanding of danger is different. Also, children can get hurt in all sorts of situations, from bicycle and car accidents to daycare negligence, dog bites, and more. North Carolina is one of 4 states that follows the doctrine of contributory negligence, which states that if a person is 1% at fault, they are barred from any recovery for compensation, even if the at-fault party is 99% at fault. This is the first area where children are treated differently. The doctrine does not apply to children under the age of 7. For ages 7 to 14, children are presumed to be incapable of contributory negligence, which places the burden on the defendant. When they turn 18, they are treated the same as an adult. When it comes to child injuries, it's not just about the physical pain. There can be emotional scars also. So when you file a child injury claim, you're looking to cover things like medical bills, pain and suffering, the emotional toll, any permanent scars and injury, or how this may affect their future quality of life or earning ability. Now, who's on the hook when it comes to child injury cases? Well, it could be an individual, a company, or even a government entity. It all depends on the specific circumstances of the case. Here's a critical thing to remember in the second area where children are treated differently than adults: the statute of limitations. Normally, you have 3 years from the accident date to file a lawsuit, or your claim is forever barred. But here's the twist. If the injured party is a minor, they have until the age of 18 plus 3 years to file the lawsuit. Please note, this only applies to the child's injury claim. Since the parents are responsible for the medical bills, their lawsuit must be filed within 3 years of the incident. The third area where children are treated different than adults is what happens to the child's settlement recovery when the case is resolved. With children, the net recovery is held with the clerk of court in a safe deposit type account until they turn 18 years old. If you need to access those funds for your child's benefit, you will need court permission to do so. When it's a large sum of money, it is preferred that the funds be placed in an annuity that is paid out over a longer period of time and usually at a much higher interest rate. Now, in a situation like this, you do not want to go at it alone. Seeking legal guidance is a must, and the sooner, the better. That's why I recommend reaching out to Auger Auger for a consultation. We can help you explore your options and make sure your child's rights are protected.